Breaking. We are witnessing what could be the most significant development in Second Amendment law in over a decade. The Supreme Court just handed down a 6-3 decision that is sending shockwaves through the gun rights community, and at the exact same time, the Department of Justice has made a stunning move that could permanently end assault weapon bans across the entire United States. This is not a drill. This is happening right now, and the implications are absolutely massive. The tide isn't just turning, it's a tsunami. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. You can also turn on all notifications because that helps to ensure that YouTube will send you these videos once I release them. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, Attorneys for Freedom, and they're always expanding upon their benefits to try to give you the best coverage that you can get as a member. If you're a gun owner, you need legal protection. It's not a question of if, it's a question of when you might need it. So check out Attorneys on Retainer. I'll link them down below. But again, thank you so much to AOR for sponsoring and supporting this channel. So let me be very clear about what just happened here, because this is a two-part development, and both parts are absolutely critical to understand. First, the Supreme Court issued a 6-3 decision that directly addresses the framework that lower courts must use when evaluating gun regulations. Second, the Department of Justice, traditionally the enforcer of federal restrictions, is now being forced into a corner where even their own Civil Rights Division is filing lawsuits against bans they once defended. This creates a perfect storm of legal and political pressure that could end assault weapon bans permanently. To understand why this 6-3 decision is so devastating to gun control, you have to understand the trap the lower courts set for themselves. For years, liberal-leaning circuits, the 2nd, the 4th, the 7th, and the 9th, used a trick called interest balancing. They would say, sure, you have a Second Amendment right, but the government's interest in public safety outweighs it. This was called intermediate scrutiny, and it allowed courts to uphold virtually any gun regulation as long as the state could point to some public safety justification. Then came Bruen. In New York State Rifle and Pistol Association versus Bruen, Justice Clarence Thomas, writing for the 6-3 majority, didn't just strike down a New York law, he nuked the entire way judges look at the Second Amendment. He said, from now on, if the text of the Second Amendment covers your conduct, like owning a rifle, the government must prove that the ban is consistent with the historical tradition of 1791. No more interest balancing, no more public safety exceptions, text, history, and tradition. That's it. But here's what happened. The lower courts tried to rebel. They've claimed that AR-15s are military-style weapons that aren't protected. They've twisted the historical analysis. They've cherry-picked obscure laws from the 1700s, and they've found ways to uphold gun bans that clearly violate the Second Amendment. The Supreme Court just said, in no uncertain terms, that this ends now. The 6-3 majority opinion, which was written by Justice Thomas, doubles down on the Bruen standard and makes it even harder for states to justify modern gun regulations. Justice Thomas specifically called out several circuit courts for essentially cherry-picking historical laws, misinterpreting their scope, and stretching historical analogies beyond recognition. The court said that historical analogies must be truly analogous. They must regulate the same type of arm for the same reasons, with the same level of burden. You can't take a 1700s law about storing gunpowder in residential areas and use that to justify a modern ban on semi-automatic rifles. That's not how the analysis works. Now, here's where this gets really interesting. The court didn't just issue this decision in a vacuum. The timing of this decision appears to be strategically coordinated with what the DOJ is doing. And what the DOJ is doing is absolutely unprecedented. Under Attorney General Pam Bondi and Assistant AG Harmeet Dillon, the Department of Justice has undergone a 180-degree turn. The DOJ has filed an amicus brief in multiple pending rifle ban cases, and in that brief, the DOJ is arguing that assault weapon bans are unconstitutional. You heard that right. The federal government, through the Department of Justice, is now officially taking the position that AR-15 bans, magazine bans, and so-called assault weapon bans violate the Second Amendment and cannot be enforced. Let me explain why this is such a massive shift, and why this could permanently end these bans nationwide. When the DOJ files an amicus brief supporting gun rights, that carries enormous weight with the courts. The Solicitor General's office is one of the most respected legal offices in the country, and when they take a position, courts listen. But it's not just about the weight of the argument. The DOJ's brief does something that we have not seen before. It lays out a comprehensive legal framework that would make it virtually impossible for any state to justify an assault weapon ban under the Bruen standard. The DOJ recently sued the District of Columbia in December 2025, alleging its assault weapon ban is unconstitutional because it targets firearms in common use. For the first time, the DOJ is using its Civil Rights Division to investigate local police departments like the Virgin Islands and Los Angeles County for unreasonable delays in issuing carry permits or imposing illegal storage requirements. This is a complete reversal from previous administrations, and it represents a fundamental shift in federal policy on the Second Amendment. So let's break down what the Supreme Court decision actually says and what the DOJ is arguing, because this is where things get devastating to assault weapon bans. The case dealt with a state law that banned certain semi-automatic rifles based on cosmetic features. The lower court had upheld that ban by arguing that these rifles were, quote, unusual and dangerous, and therefore not protected by the Second Amendment. The lower court also said that even if these rifles were in common use, the state had a compelling interest in banning them for public safety. This is exactly the kind of reasoning that the Supreme Court has been warning lower courts not to use, and now the court has definitively rejected it. Justice Thomas, writing for the majority, said that the Second Amendment's plain text covers these firearms, period. He said that AR-15s and similar rifles are in common use for lawful purposes, which means they are presumptively protected arms under Heller and Bruen. And here's the critical part. When a firearm is in common use, the burden shifts entirely to the government to show a historical tradition of regulating that type of arm. The government cannot meet that burden by pointing to modern interest balancing, public safety concerns, or evolving standards of decency. They must show actual historical regulations from the founding era or the Reconstruction era that are analogous to the modern ban. Let's look at the numbers, because this is where the common use test becomes impossible for states to overcome. There are an estimated 20 to 24 million AR-15 style rifles in the hands of law-abiding Americans today. If 24 million of something isn't common use, then the English language has lost all meaning. The DOJ's brief cites these statistics and argues that under Heller and Bruen, firearms that are in such widespread common use are presumptively protected by the Second Amendment, and states cannot ban them simply because they don't like them or because they think they're too dangerous. Justice Thomas also addressed the so-called dangerousness exception that some lower courts have been trying to create. He said that there is no dangerousness exception to the Second Amendment. The fact that a firearm is dangerous, or even more dangerous than other firearms, does not remove it from constitutional protection. In fact, he said, the Second Amendment specifically protects arms that are useful for self-defense and militia service, which necessarily means arms that are dangerous and effective. The entire point of the Second Amendment is to protect access to arms that can be used to resist tyranny and defend liberty, and you can't do that with arms that are not dangerous. The three dissenting justices, Sotomayor, Kagan, and Jackson, wrote a dissent arguing that the majority is being too rigid in its historical analysis and not giving enough deference to state legislatures. Justice Sotomayor wrote that the majority's approach will lead to the invalidation of many reasonable gun safety laws and will make it harder for states to address gun violence. But here's the thing. The dissent doesn't really engage with the historical analysis. It doesn't point to specific founding-era laws that would justify assault weapon bans. Instead, it essentially argues that the court should use interest balancing and that public safety should outweigh individual rights. But that's exactly the approach that Bruen rejected, and now this new decision has rejected it again even more forcefully. Now let's talk about what the DOJ is doing in detail, because this is the part that makes this development truly unprecedented. The DOJ argues that the historical record does not support assault weapon bans. The brief goes through the historical analysis in painstaking detail, examining founding-era laws, Reconstruction-era laws, and early 20th century laws. And the conclusion is clear. There is no historical tradition of banning entire categories of firearms that are in common use for lawful purposes. The DOJ points out that even during the founding era, citizens were allowed to own military-grade weapons, including rifles that were essentially the assault weapons of their day. The idea that the government can ban a class of firearms simply because they are effective or powerful is completely foreign to our constitutional tradition. And this is really important. The DOJ argues that states cannot use magazine capacity limits as a backdoor way to ban these rifles. Many states have tried to ban magazines over 10 rounds, which effectively makes many modern firearms unusable or significantly less effective. The DOJ argues that standard capacity magazines are also in common use, and banning them violates the Second Amendment just as much as banning the rifles themselves. The brief cites evidence that magazines holding more than 10 rounds are the factory standard for most modern firearms, and they are widely used for self-defense, sport shooting, and lawful purposes. Why is the DOJ pushing now? It isn't just out of the goodness of their hearts, it's because the legal framework has become so lopsided that the DOJ knows they will lose. If they don't lead the charge to regulate how these bans end, the Supreme Court will end them with a sledgehammer, leaving no room for any restrictions at all. The DOJ is currently scrambling. They are filing amicus briefs, trying to tell the court, okay, maybe you can't ban them, but let us keep the registration lists. But the 6-3 majority is looking at the history of 1791, and guess what? There were no registration lists for the muskets and multi-shot experimental weapons of the founding era. This is the breaking part of this story. We are hearing reports that the court is no longer interested in remanding these cases back to the lower courts to let them try again. They are ready to take the assault weapon issue head-on. They are ready to define, once and for all, that arms means what the people actually own, not what the government wants them to own. So where does this leave us right now? We now have a Supreme Court decision that makes it much harder for lower courts to uphold gun regulations, and we have the DOJ actively arguing that assault weapon bans are unconstitutional. States like California, New York, Illinois, Maryland, Massachusetts, Connecticut, and others are now facing an uphill battle to defend their assault weapon bans. This isn't just about Maryland or Illinois. This is about a permanent national precedent. If the Supreme Court issues a 6-3 ruling stating that semi-automatic rifles are protected arms under the Second Amendment, every single state ban will fall like a house of cards. The Supreme Court still has several rifle and magazine ban cases pending on their docket. 3 major petitions are currently being distributed for conference, meaning the justices are deciding whether to hear them. Viramontes versus Cook County, a challenge to the Illinois assault weapon ban, was distributed for conference on January 23, 2026, and remains under active consideration. It specifically asks if the Second Amendment guarantees the right to possess AR-15 platform rifles. Duncan versus Bonta challenges California's magazine ban limiting capacity to 10 rounds. The petitioners argue that magazines are arms and that California's ban violates the takings clause by dispossessing citizens of property without compensation. And there's a new petition following the Fourth Circuit's ruling which called AR-15s military-style weapons, which is the most likely candidate for a 2026 merits hearing. If the court grants cert in any of these cases, we could see a final definitive ruling that strikes down assault weapon bans nationwide by the end of this term. But even if the Supreme Court doesn't grant cert right away, this new decision and the DOJ's position will have immediate effects in lower courts. District courts and circuit courts are now on notice that they cannot play games with the historical analysis. They cannot use interest balancing. They cannot create exceptions to the Second Amendment based on dangerousness or public safety. They must follow the text, history, and tradition test as laid out by the Supreme Court, and if they don't, their decisions will be reversed. We're also likely to see a wave of new litigation challenging existing assault weapon bans. Gun rights organizations now have a Supreme Court decision and a DOJ brief that they can cite in every single case. Plaintiffs who are challenging these bans now have powerful ammunition, both literally and figuratively, to argue that their rights are being violated. And states are going to have a much harder time defending these laws because they can't point to historical analogs that actually support what they're doing. There's another piece to this that we need to talk about, and that's the political dimension. The fact that the DOJ is taking this position represents a massive political shift. For years, the federal government has either defended gun control laws or stayed neutral in these cases. But now, the federal government is actively fighting against assault weapon bans. This sends a signal to state legislators, to governors, to attorneys general, that the federal government is serious about enforcing the Second Amendment and will not tolerate unconstitutional gun bans. This could also have implications for federal legislation. There have been efforts in Congress to pass a federal assault weapon ban, but with the DOJ now on record saying that such bans are unconstitutional, it becomes much harder politically to push for federal legislation. Members of Congress who support gun rights can now point to the DOJ's position and say, even our own Justice Department admits that these bans violate the Constitution. So what does all of this mean for gun owners? Well, if you live in a state with an assault weapon ban, this is potentially very good news. These bans are now under serious legal threat, and there's a real possibility that they could be struck down in the near future. If you've been thinking about purchasing an AR-15 or a similar rifle but have been unable to because of state laws, you may soon have that opportunity. However, and this is important, these bans are still in effect right now. You cannot violate current state law just because you think it's going to be struck down. You need to wait for an actual court decision or a change in the law before you act. If you live in a free state without these bans, this decision and the DOJ's position help to ensure that your state won't be able to pass these kinds of bans in the future. It creates a strong legal precedent that makes it much harder for anti-gun legislators to push these laws through, and if they do try to pass them, you now have very strong legal grounds to challenge them in court. Now, I want to be clear about something. This is a huge development, but it's not over yet. The legal fight is going to continue. States are going to keep defending their bans. Lower courts are going to keep issuing rulings, and the Supreme Court is going to keep deciding which cases to take and which cases to deny. But the momentum has clearly shifted in favor of gun rights, and this decision combined with the DOJ's position represents a major turning point. Here's what you need to watch for in the coming weeks and months. First, watch to see if the Supreme Court grants cert in any of the pending rifle ban cases. If they do, that would be a huge signal that they're ready to issue a definitive nationwide ruling on assault weapon bans. Second, watch for lower court decisions in ongoing cases. Courts are now going to have to apply this new Supreme Court decision, and we'll see very quickly whether they're willing to follow it or whether they're going to keep trying to find ways around it. Third, watch for new litigation. Gun rights groups are going to be filing new lawsuits challenging assault weapon bans in multiple states, and those cases are going to move through the courts relatively quickly given this new precedent. The bottom line is this: we are potentially witnessing the beginning of the end of assault weapon bans in the United States. The Supreme Court has issued a decision that makes it much harder to justify these bans. The DOJ has taken a position that these bans are unconstitutional, and the legal and political landscape has shifted dramatically in favor of gun rights. The 6-3 conservative supermajority, Thomas, Alito, Gorsuch, Kavanaugh, Barrett, and Roberts, is now staring down a simple reality. You cannot call a firearm unusual when it is the single best-selling rifle in American history. This doesn't mean that the fight is over. Anti-gun forces are going to keep pushing, states are going to keep defending their laws, and there will be setbacks along the way. But the trajectory is clear, and the momentum is on the side of the Second Amendment. We are about to see a decision so clear, so powerful that the term assault weapon could be deleted from the legal dictionary forever. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. Make sure you hit the like button. All of that tells the algorithm that you appreciate this type of Second Amendment content, and it should share it to more people. Drop a comment down below and let me know what you think about this Supreme Court decision and the DOJ's position. Do you think this is finally the moment when assault weapon bans come to an end? Or do you think states are going to find new ways to defend these laws? I want to hear your thoughts. As we get more developments, as we get new court decisions, as we see how this plays out in the coming weeks and months, I will let you guys know. This is a developing story, and it's one of the most important Second Amendment stories we've covered. But as always, thank you so much for all of your support.